This Thursday afternoon, February 26th. We're now turning our attention to draft number 1.14 of H385. Who's starting? Maria?
I think so. Yeah.
And are we tag teaming with Michelle?
Yeah.
Do we have the pleasure of two legislative council at the same time? This is awesome.
Sure.
Great.
It's at least two on this one.
Can't say that because we need another committees too, right?
Oh, boy. Okay, Maria Royal with Legislative Council. A couple things. One, I apologize for the green highlighting, which in the printed copy is actually very hard to read. Online, it's beautiful, but I forgot that you like hard copies, so apologies for that. So in terms of what this draft is, I reviewed draft 1.13 yesterday with Commerce. Those are all of the highlights that are in yellow. Still some to be determines in Commerce for sure. And then in yellow also were a couple things that Commerce looked at yesterday that this committee had actually proposed. So I'll flag those. And then we'll pretty much stick to the proposals that are in response to some of the questions and concerns you had. Okay, so with that said, the very first issue that came up in this committee is on line 13 of the first page, which is whether you had to specify that the police report had to be an official valid copy. And I think the answer is you don't have to actually specify that. It's inherently official. If it's not valid, it won't help you
Angela will be pleased.
presenting your case, right? So then also on page 3 in yellow, lines 12 and 13, one of the issues you raised was ensuring that there was some kind of conflict of interest provision with respect to the qualified third-party professionals. So these are people that can sign a certification on behalf. All right, so it just says any of the following individuals who do not have a conflict of interest.
And that's understood what would constitute a conflict of interest is.
I think so. I talked to Michelle about this a little bit. If there are specific things you want to call out, I did look actually at a similar provision under a federal law that pertains to federal employees, and it just says don't have a conflict of interest, and then has like the guidance with it, but it doesn't specify. If you want to say no personal, financial, it's really a policy choice. There's a concern.
I would think it makes sense that it says conflict of interest. I mean, I think there's general understanding.
Yeah.
Yes, I don't think we need a list.
Okay, and then so the next change on page 4 was just an addition of the word future. So there are a number of provisions related to the disclosure, the debtor's disclosure of the perpetrator's identity. So we'll get to some more substantive changes there, but just in terms of what's in the statement of coerced debt, just clarifying that the information will likely to result in future abuse to the debtor or member of the family. And that brings us all the way to the civil legal remedies, which start on page 15.
Thanks.
So subsection B, this is if a court finds that debt is coerced debt, what happens then? What does that, what actions can occur after that fact? And there's a proposal that was offered to specify that, what's that?
Would it be helpful if I do that section?
That would be great, yes. You want to talk about?
Do you want to go through with any other changes that you
Well,
made?
I was
Or
going,
just the ones that we talked
I
about
think the
yesterday?
rest of those are the new provisions with one exception, which I'll just mention because I'm up here. And that's on page 18. It's actually highlighted in blue. And this was with respect to the statute of limitations, particularly in an action by a creditor against a perpetrator. I think you wanted more of a kind of a date certain. So what it says here, 6 years after the date the creditor received the debtor's statement of coerced debt and adequate documentation, or received notice of the identity of the perpetrator, whichever is later.
Yes.
But, okay.
Yeah.
So I think that's it. Michelle's gonna take over the rest. Well, almost, I'm just gonna add one more thing in case you're curious. Commerce added, starting on page 23 on, there's kind of a new proposal here, and it's related to protecting individuals from financial exploitation at financial institutions, and basically allows banks to institute a bank hold on transactions if they think there might be some kind of suspicious activity. Somebody might be victim to a scam. So anyway, I'm not going to go into detail, but I just wanted you to know that that had been added on in case you're wondering what the rest of this is all about. So I think that's it for me, and I think Michelle will go through the civil legal remedy provisions. Yes.
So can I talk about that new provision now, or do you want to go through those?
Which one?
The protection from financial exploitation.
Oh, sure, whatever. And if I can walk through it in more detail if you like.
No, I don't think so. I'm just looking at page 27 and 15 to 21. The authority to delay a transaction under this section expires at the earlier of 15 business days after the date on which the covered entity initiated the delay. Well, actually, so let me ask this question. So they can delay for a certain amount of time. Like, maybe you need to just tell me.
Because I see the report order, so I feel like
Yeah,
that's
there's
something within our
couple
realm.
report orders, and there was an explanation in our caucus
Yes.
week and a half ago, that caused me some concern, and I just want to make sure that that's not in there. So
Absolutely.
yeah,
Okay.
thank you.
Yeah. And so is it helpful to kind of go back and go through it section by section, or broad overview?
What's the broad overview, the concept?
Okay. So basically, in general, financial institutions are under an obligation to serve their customers and at their request, all of their assets, et cetera. What this proposal seeks to do is, if a bank or financial credit union, financial institution has a concern that somebody might be coming in with asking for a large withdrawal or transfer, and it seems suspicious, this gives them authority to place a hold on the transaction for 15 days, to maybe have conversations, if possible, with the customer, or potentially contact a third-party person who may be a trusted contact specified by the customer, a family member of the customer, if the financial institution thinks that that's a good thing to do. But basically gives them some authority to try to,
Okay, so it's a 15-day period that they can hold or delay the transaction.
up to 15 days.
So here's my concern then, right off in going to page 27. Now, I assume just the way this is structured here, there's not any kind of current case that's involved. This is a person comes to the,
Yes.
right. So I think it's really sending a false sense of hope to individuals saying, there's a court order directing the release of funds. There's no way anybody within 15 days is going to get a court order to release those funds. So I just think that just doesn't work. So,
Okay, yeah.
Good question. I
yeah.
mean, that's my feeling too. I was like, oh, shoot, what if somehow I get caught in this? And I'm like, no, I really just need this money and I want the money. So is there any precedent of the bank being able to hold for 15 days and has to go through all these hoops? Like, I'm just trying to think of the person who legitimate just wants their money because I need to make a payment for XYZ.
Absolutely. And I think that's part of the difficulty. And some of it is left to the discretion of the bank. You know, they generally just want to do what their customers have. And you can hear from the financial entities how they're going to, because they have duties and obligations to meet customer requests.
I mean, I'm assuming, if somebody's very sophisticated, they can go and they can seek a temporary restraining order on very, very short order. But that probably should be spelled out a little bit because I don't think most people, since what, 80% of people who go into our civil courts are not represented. So I'm flagging that as a concern for, maybe we can have Judge Zoning weigh in on that as well, and Chris, if you want to weigh in. That's sort of- All right, back to.
Just flag on the next page too, probably.
Yes.
Issue. Okay,
Well, thank you.
so, sure,
For explaining that was there as well.
you're welcome. Shall go through them.
Again, appreciate a tag team. It's a very special day for.
Don't get used to it.
Judiciary. What?
For the record, Michelle Tiles, Office of Legislative Counsel. So I was looking at a pretty narrow and yet quite unwieldy part of this. And I was working with Ian in concert with kind of sharing drafts with the network as well as Judge Zone on trying to find some language that might be agreeable to folks. I don't know that we've done it, but thought that we'd get something on the page for conversation. And so I think Maria just talked to you about one change that was made. If you look at, let me see, it's on page 4, and this has to do with subdivision 9A on the definition of statement of coerced debt. And you'll see in Romanet 5 is that just the word future has been added there. This issue about the likely to result in future abuse to the debtor or a member of their family if they disclose the identity of the perpetrator. I just wonder if I said like the term abuse, right? So you have a definition of domestic abuse in here, right? And it cross-references your definition of abuse in Title 15 under your civil chapter for obtaining an RFA. Okay, so and you remember it's very specific things around that qualify as abuse according to that definition. I get what is intended here, right? But then I just want you to keep in mind about this, future abuse, because when you're talking about the group of folks who can perhaps avail themselves of this process, it's folks who may have been victims of domestic violence, but also human trafficking. It could be abuse, neglect, or exploitation of a vulnerable adult, especially if you're talking about someone who's elderly. We have on the books, we have financial exploitation of a vulnerable adult. And so the question that we were trying to kind of bat around here, which is like, what is the danger, right? So if you're talking about abuse, and you're tagging it and you're already defining abuse as domestic abuse, as in what you have in Title 15, right? Which is a fairly high standard, right? Or are you thinking in terms of you don't want the perpetrator, like there's a danger that the perpetrator is not going to engage in that technical definition of abuse, but they may harass the person, dox the person, do engage in all kinds of different behavior, threats, or all sorts of things that might not qualify necessarily as abuse. So I just kind of bring this up, and I don't have a great solution. It's really a policy decision for you about what you're looking to, what is going to be that threshold that they have to show in terms of, what is the danger, right? And then we can craft language around that. But I just wanted to kind of highlight that here, that language appears here in the definition, and then the issue comes up again on page, like when you start on the civil legal remedy. Civil legal remedy starts on page 15. I'll just mention, and not that nobody's wedded to this language, but this morning was pretty crazy. There were a lot going on. you know. And I know that the bankers had raised some issue around the need to vacate any previous default judgment. That's just kind of a placeholder there, and I'm sure you know, they can testify and work with Maria on what they want in that space, but I just stuck it there for now. But if you look at page 16, and it's a little hard to read, and Maria is right, it does look beautiful online, actually, that green. More of a spring green. So I might just kind of read it out to you so you can see. So it's amending subsection C. And again, there's a lot of policy decisions in here that in working with Ian, you know, some decisions were made. You don't have to stick with them all, but it's for discussion purposes. So you'll see under existing subsection C, left the first sentence, but struck the language around the creditor not being able to compel the debtor to disclose the identity. And that's because we have new language in a new subsection D. And this is that if the debtor signs a sworn statement disclosing that the identity and contact information for the perpetrator is likely to result in future abuse, so there's that term again that we have to think about, what do you want to use there, to the debtor or a member of the debtor's immediate family, the creditor may file a motion requesting a hearing to determine the danger of future abuse to the debtor or to a member of the debtor's family if they disclosed information. If the court finds that the debtor and it has to be, the burden is on the debtor, and they have to show by a preponderance of the evidence that the perpetrator poses a danger of future abuse if the debtor discloses that information. So if the court finds that the debtor meets the burden, then the debtor shall not be required to disclose the information. However, if the debtor does not meet that burden, then the court shall order the debtor to disclose the identity of, and if known, the contact information for the perpetrator. So there's a lot of policy decisions in there for you about which way to go.
Well, I'm just wondering, are those last two sentences necessary? Isn't that? Probably not. I mean, yeah, if they prevail, they.
Yes, but sometimes we say it, but you don't have to. It's just making it clear that the court is to order the disclosure, and if not, but you don't have to. I'm fine with it out.
Fine if people want to present. I was just curious. Karen?
Just trying to put, did you go?
What?
Is it on that section?
Yeah.
Yeah.
Oh, no, I was just gonna say like the sort of like decision points that we sort of made a decision on just to get something on here was like where the burden falls on what's part of this test. So like the question was, should like the creditor or should the debtor need to make a motion to have the perpetrator's identity withheld? And we decided no, let's have it. If they file this document, which is already described earlier, this document, then we're going to say it's got to be the creditor who makes the motion. So that's like a policy. We could change that, but we kind of built it this way for looking at. And then the other one was who's got the burden once the question of whether the perpetrator is going to be concealed or not. And it could either be on the creditor to satisfy the burden or the debtor. And we said, let's put it on the debtor because they're the one who is going to be able to actually testify about like whether the risk of future harm is there. So I think like those are the two questions. Like,
and then also a big difference from what was there before is that the court can compel the debtor to disclose.
Yeah.
Doesn't the movement usually usually have the burden to prove whatever they're.
Well, yeah, but we have like a weird prima facie structure in this.
Might as well continue it on.
Right. Well, like, so like, you know, you're like kind of moving, but then they don't really have, they file all this like.
I mean, if you had it, and if the creditor is like, because they're not necessarily always going to maybe want to challenge it. So it kind of seems like it should be their decision about whether or not they will. But really, what are they gonna, if they don't know the identity of the perpetrator? I mean, it seems like it would be hard for them to show in any way by preponderance of the evidence that the person, is not facing danger, right? Because they don't have the information
No,
to be able to prove that.
I was thinking that, and we went over this, and maybe that's why you've landed here, that we were talking about, well, the debtor should have to move for the protection, and then they'd have to prove the protection. But-
Yeah, and I think where we moved back was, well, maybe you could have a lot of situations where the creditor never really wants to sort of challenge it. And so if they're making it clear that this is, they filed the thing that says that future harm is likely if we disclose, making it so that the debtor doesn't have to make another move again to, because they've already filed this thing.
So is the sworn statement as part of what that statement is?
Yeah, so back
On page 4.
page 4. Yeah, so they're already filing this as part of their prima facie document
Right.
structure.
That makes sense to me.
So this is backing up just a little bit further. I'm trying to confirm the piece about abuse that you're
Mhm.
saying that we have to better define what that,
Well, I think
the piece that I'm going to ask though, and I see
Mhm.
that Judge Zonay is on there. Is it not up to the discretion of the judge right now? And they can.
It
they can
is,
determine it.
but I think a number of concerns that were from the court were around that there was not enough guidance to the court to be making various determinations. And you remember the earlier language had around, the court shall make such orders necessary to protect the, I want to say the plaintiff, the debtor. And I think the court was concerned that it sounded as though maybe you could read into that there could be maybe some shortcut to an RFA in there, whatever, and that's not the intent. So what we've done is boil down the language to be really small, is that these remedies are possible if they find that there's danger of future abuse. But, and certainly hear from Judge Zonay on this, but I think in our discussions, it was kind of like, well, in this context, danger of future abuse, what does that mean? And does that need further fleshing out? My concern is that you already use the term domestic abuse in this bill and in the definition section, and it tracks
to that.
it tracks to Title 15. And I guess my question is, and it would certainly make it easy, is that if you then are fine with it just meaning that Title 15, Section 1101 definition of abuse, which well, right. So I think that was my guess, is that you wanted it not just to be something that met that particular standard, but that there's all kinds of things that somebody could kind of unleash on someone and retaliation. And I think you want to just be a little clearer about what that would be. So would it be, if there's danger of, threats, or you guys have dealt with these kinds of things before, harassment, intimidation, threats, to
No, this is
bodily
helpful.
injury,
We can talk to
that
Judge
kind of-
Zonay about that.
Yep.
Like, how does he read that and what guardrails might need to be there?
Right. And then I also just want to mention here is there's, language. I haven't gotten to that yet. So
Thank you for that.
let me just go down to the next one, because then maybe, and I don't know that, I suspect this isn't sufficient for the court based on their earlier comments, but I think what Ian and I were trying to do is try to pull everybody's interest together and see if we could meet somewhere in the middle. So there is a new subsection E, which is that in any action involving alleged coerced debt upon motion of the debtor, okay, the court may seal records in accordance with Rule 9 of the rules for public access to court records. So it's tracking, so it's connecting it to existing court rules, redact personally identifiable information, and direct that, or I should maybe make that an or direct that any deposition or evidentiary hearing be conducted remotely to protect the debtor or a member of the debtor's immediate family from an alleged perpetrator. And then there's language saying that if a debtor is seeking an RFA or an order against stalking or sexual assault, then they go to those sections and they follow those sections just like they are set forth, because these actions are going to be presumably in the civil division. RFAs are exclusively within the family division, right? And so if it's a family member, you would go and you would seek a protection order just like you would normally under those circumstances. There's no alternative route through this process. And so by removing the earlier language about saying kind of generally that the court shall make such orders, to protect the debtor, we've removed that and said very specifically, you can seal records, you can order a remote deposition or evidentiary hearing, and you can redact personally identifying information.
Yeah.
And just to follow it up, we're also sort of providing some pretty explicit things that a civil court could do that's not outside of what I think is reasonable. And like we're identifying that if you want to get so far into protective order that it would be an RFA, that we're identifying the RFA, go do it there, not here. And that and I'd be curious to hear what Judge Zone says, but just that you can move the court right now in a civil proceeding to have a deposition done when somebody is about to die, that you don't think they're going to be alive for this civil trial. And there are ways that you can move the court to work with a plaintiff or something that I don't think it's so outside of the realm of a civil proceeding to seek these sort of reliefs.
Okay. Any other questions for Michelle? So you've gone through everything that you need to go through?
That's just my little slice.
It's an important place. Who do you think we should hear from next? Yeah. Do we hear from
Probably Judge Zone.
Charlie or
Judge.
Do you want Judge Zone?
I do. I have questions already.
Well, I know you have questions, but there could be more questions that come up after we hear from Chris and Charlie. But then
I guess, actually, do you want to do Charlie and then Chris and then Zone can wrap it up?
Yeah, thank you, Judge.
Go on order, and we have more questions, we can always bring them back.
that's true. Let's go Judge Zone first, and then if he can be sticking around to hear the rest of the testimony in case something else comes up, that'd be great. Thank you for appearing, for being here.
My pleasure. Good afternoon, Tom Zone, Chief Superior Judge. So I do have what I believe is the most recent version. I had looked at we'll call it the green highlights, which I think were the changes that were for your committee. If you go to page 15 on line 16, this is that language that was added that I think Michelle mentioned might be a placeholder about default judgment. It says the court shall vacate any previous default judgment issued against the debtor related to the coerced debt. I think the word related might be a little broader than you need. There is a specific debt and you know it. So if it just says any previous default judgment issued against the debtor on the coerced debt, so it's that specific debt and there's no potential to expand that.
Right.
And for what it's worth, what you're essentially doing with that is under Vermont law, under the way we have in the rules of civil procedure, there's a rule 55 that deals with default judgments. And there are standards for vacating a default judgment. And those standards depend on whether the default judgment has been issued. So when a motion to vacate is filed after the entry of a default judgment of what's called default, but before the judgment order is entered, because it's a two-step process under Rule 55, someone is defaulted and then the court issues the order. While oftentimes it's done at the same time, it is a two-step process by rule. And so if it's done in that interim, the question is there's good cause and the court can vacate it. But where we would normally see it is that if the judge enters a final judgment order, it falls then under what's called Rule 60. And Rule 60, 60B, as in boy to be precise, permits relief from final judgment for several enumerated reasons. One of those reasons is number 6. And it says any other reason justifying relief from the operation of the judgment. And so the question would be, is this statute any other reason justifying relief of operation. In other words, this kind of overrides that. And so that will be a question for the courts to address, but it certainly is clear that the legislation intends for this to be another reason to override a default judgment after final judgment. But again, that's a question that could come up.
Judge, on it, just really quickly, could we just say at the end of this pursuant to VRCP Rule 60B?
Well, if you say pursuant to Rule 60B, that's one thing, but they already have that right. And so it seems like the policy you're trying to advance here is that that the debtor doesn't just have a right under Rule 60, but the debtor has an absolute right that the legislature is creating anew for them to have it vacated. And so if the idea is to have a separate vacation statute, as this appears to be, then you don't want to tie it back into 60 because that just puts them what they already had already.
Yeah, that makes sense.
Then on page 16 was the language about the sworn statement that was placed into this new section, lines 9 through 21, it looks like. If you go to line 13, it says the debtor shall bear the burden of proving by a preponderance of the evidence that the perpetrator poses a danger of future abuse to the debtor or to a member of the debtor's immediate family if the debtor discloses the identity of and contact information for the perpetrator. Now, I know what that is intended to say. And I have to say that when I read it the first time, I went, wait a minute, does that only apply if they disclose? And that's not the intent. I know what the intent is. So if I could just suggest a tiny change, it would say the debtor shall bear the burden of proving by a preponderance of the evidence that if the debtor discloses the identity of and contact information for the perpetrator, that the perpetrator poses a danger of further abuse, and continue it from there. In other words, just take that last clause and move it up in the center to make it clear that it doesn't only apply if they make a disclosure.
Got that?
Okay. I think that,
I can send that along.
okay.
Karen has a question.
Judge, thank you. Maybe you're going to get to this. I just want to make sure you can speak to the abuse piece of it, of your interpretation of that.
So your specific question on that, because domestic abuse is defined under Title 15.
Yeah, so but in this, it just says future abuse. So would you understand that to be just domestic abuse, or would it be any and all abuse?
That's future abuse is broader than domestic abuse. So it is a broader category. It will require, there's a lot more out there that's potentially support for this type of order.
Okay, even though my understanding is that domestic abuse is referred in this statute earlier in it, so there wouldn't be confusion of like, oh, I should only be thinking about domestic, because I think we want it to potentially be wider.
Well, you have defined domestic abuse. And so where the word abuse appears, the question for the court would be, was it an oversight? That the legislature did not put the word domestic in there. If it's intentional and the court has to define what the parameters are under canons of statutory construction, you look to the plain language generally. If a term is not defined, there's Supreme Court cases that say you go to the dictionary definition. And so if you want to define it, that certainly is helpful, because not defining it does bring with it the potential that some judges may say it's got to mean domestic abuse. You can't just, that has to be what the intent of the legislature was. And so it's not completely clear for guidance as to how the courts are able to take care of it.
We have an expert that can let us know too.
Okay. So I'm hearing we probably need to add a definition of future abuse. Perhaps encompassing what abuse is in a domestic abuse and
Just means any kind of harm.
Well, yeah, well, let me just ask this of the judge. So if it's this broad term of abuse, any kind of harm in this process, in this process, presumably, well, I mean, no, all right, for just abuse in this hearing, the debtor would have to prove abuse, and that would be weighed against the need for that information from the predator. I mean, it's or
This
not.
statute does not have a balancing test.
Okay.
It is, if the court finds abuse, of the danger of future abuse, the way that this statute is written, that's it. The court does not get into a balancing test to say, okay, there's a danger of future abuse, but this is a $5 million claim, and the danger is pretty low, but the debt is pretty high. We don't get into that balancing test. So once you cross that threshold, 50.1% of abuse, whatever that may be defined as, the court is obligated to, under the way this is structured, to say that the name does not get disclosed. And for example, quick internet dictionary search, looks like Merriam-Webster's abuse. Use something to bad effect or for a bad purpose, misuse. Number 2, treat a person or animal with cruelty or violence, especially regularly or repeatedly. Or 3, speak in an insulting and offensive way to or about someone. And so the question for the legislature is, do you intend it to be that potentially broad, or is your intent to provide protection from domestic abuse, which itself you've added to and have coercion and control, and you've added a number of areas there that are broader than just physical abuse. And so that's the policy question.
Right, and that's problematic.
Yeah.
So that's a rhetorical question, I think, that would hurt. So why can't it be tied to the definition of abuse in 1101(1)? You don't have to call it domestic abuse. It's just that's the definition of abuse.
And-
Attempting to cause or causing physical harm, placing another in fear of imminent serious physical harm, abuse to children, stalking is defined, sexual assault is defined, and coercive controlling behavior.
And it doesn't have to be.
Except there's one difference there, and that is the coercive controlling behavior only is between family or household members.
Because it could
But if
be,
you've had, well, I guess it could be something else. I was
Well,
gonna say,
somebody-
if you've had
it's like-
previous relationships,
Right,
they live on
impacts,
the other side of the country, but if it's your.
Well, but I'm looking at the human
Ex-part-
trafficking, somebody could,
Right,
and there may be no relationship
Right.
there, but there could be any of these kinds of abuses.
I think it makes sense. You know,
Which makes sense.
so I think linking it to the abuse definition, it's a policy question. I don't actually think that this should be a balancing test against the debt.
No, but if there's not a balancing.
It needs to be
it has to be a higher standard.
I totally agree with you. Okay.
And so,
and we're gonna go broader than just household.
well, that I don't know. Because if you're just
You know
tying
what?
it to abuse,
I served on a jury where the person had done the bad thing, but they weren't in the household, and so we.
right. But was that coercive controlling behavior? Because the other, well, okay, yeah, right, it's all
something
between
like that.
family or household members, so that part have to change. But I don't know how you incorporate.
Yeah, and that's
I'll let,
I think,
Michelle.
I think this is, I think this is a side conversation.
Yeah. Oh. Yes and no. I mean,
I'm just happy to, in terms of like,
Right,
you guys,
we need to make the abuse.
figure out generally, who's your person? Is it still Ian? To be my point person?
no, I'm happy to do it.
And I guess maybe just getting some clear direction from you, that you, so I think when we were discussing this earlier, we were thinking that perhaps the committee's intent was for it to include things like threats or doxing or, you know, doing things that are essentially more kind of like harassing, intimidation, things like that, that don't necessarily fall neatly into the Title 15 definition of abuse. It's totally, absolutely your decision around, and I think having some kind of definition of, you know, I think maybe I would say future abuse.
And I wasn't quite sure, so we kind of left it.
Okay, yeah.
I do have a thought as you're talking, and that is, if the concern is that domestic abuse under 11011 requires between a family or household member, and you're looking at defining something different here for the word abuse, you might, and I haven't thought this through because this is just on the fly, but you could theoretically define the word abuse as has the same meaning as provided in 15 VSA 11011, comma, except that it need not be an occurrence. The acts need not be between family or household members, and therefore you have domestic abuse, which family or household members. And if you have another definition for the word abuse, you're getting what I think Representative Goodnow referred to as that higher standard, and you can make clear that we don't have that clause about family or household members.
Judge, the definition of abuse that you're coming up with, or I don't know if the question is for you, but is this still all tied to the coerced debt? It almost seems like it's going beyond
The standard in the bill does not require that the future abuse have anything to do with the coerced debt. A finding of abuse.
Since that's what we're doing.
No, that's it. So it's a little bit different. It's whether to turn over the name of the perpetrator if there can be proof that doing so would cause this other abuse, including, you know, threats or placing somebody in imminent serious physical harm. The whole idea is we're disclosing the fact that this the victim, the debtor, has, you know, had this coerced debt holding. So it's not really related to that. It's kind of a little bit different at that point. Does that make sense? I don't think
So
that makes sense,
this
but-
is after the coerced debt.
Right. Coerced debt has been
No,
determined.
The court has
I look
found,
at it totally different than most people in here. That if we have if we have somebody that was coerced, we have a perpetrator. To me, I don't know if it could be done at that point. An RFA is in place, and we've done a lot of work on RFAs through the years, and I think everybody would agree that they work, and we wouldn't even have to go in this direction. But that's just my opinion. The perpetrator needs to be out there, and we won't have to deal with all this other abuse stuff.
well, certainly
I know
those
I'm
are policy
outvoted.
decisions.
Yeah, trying to strike hearing that, I think that's a very real concern. And I think trying to strike the balance here by,
Yeah, but it's not a balance. There's no balance between the two beliefs systems.
All right, let's go back to Judge Zone A. We'll have
If I'm not mistaken, you also had, I would also note that the definition of abuse under 1101, if you tied it back into that, includes the stalking definition from Title 12. And so that is a little broader than just, again, physical violence. That talks about course of conduct. It means that someone engages purposefully in a course of conduct directed at a specific person, knowing or should have known that it would cause them to fear for safety, suffer substantial emotional distress. So that also brings in that potential into the definition. There was a question, I believe, on page 27, the language about the 15 days. Am I correct?
Yes.
yeah,
And
You said it was wrong.
Yeah, did you have
That
anything
had-
else on, you didn't have anything on page 17 or anything? That was all for that section?
yeah,
I'll make sure.
Again, it's page 60. Oh, I'm sorry, page 17. The only thing I would do is on line 2, I'd get rid of the word presiding. It is the court. We know it's going to be the court. The new language takes the it takes it away from the concern that I had expressed about the court having to serve as the advocate, if you will. It puts the burden on the debtor to file something to say we want relief. It removed the language that was difficult to implement because it was with questions about authorization, scope, and limits. And what it now says is that if the debtor files, the court can seal records. It tethers it to the existing statute, the existing court rules on how to seal records. It also talks about some other provisions of the law other provisions that a judge could order. And I think Representative Goodnow correctly noted it, that courts can order certain types of restrictions and provisions when we're dealing with discovery and court matters. And so they are the type of orders that we could enter anyway, generally, but it's very clear to say this is the type of orders that you can order. And I don't know, I think it's not necessary to have lines 10 through 13 there about a debtor seeking relief may file. It's not, doesn't do any harm to say they can file for those orders, but it certainly is not critical because they have that right anyway, irrespective of it appearing here.
All right, jumping to page 27 then.
Page 27, do I correctly understand your question is it realistic for an order, everything to be taken care of in 15 days?
Yeah, I mean, it is with the temporary restraining order, presumably, and all of that, but are they going to be able to? It seems to be kind of a false promise to some extent to put it in.
It does. I would concur that the idea that this is going to be a readily used, easy process for someone to say, okay, we're putting a hold on this because we think that there's a problem with this transaction. We're doing protective measures, and now we have 15 days. They've got to get their attorneys involved. They've got to take steps. So I don't know if that's really going to work. Now, a difference is, however, that if they take that step and put the notice out, there is the very real potential that there could be a financial exploitation complaint filed within that 15 days. That's much more realistic. And so if there's a financial exploitation complaint filed for an elder abuse situation, the court could then order that the creditor would extend that, something like that, for protection.
But this would be the person seeking the money wanting a court order so that they can get their money earlier. But you're talking about something different.
No, what I'm saying is, let's say an individual goes. They are an elderly individual goes to the bank to get money. As I understand this, the idea is the bank can say, "There's a problem. We think there's an issue here." They watch them, whether they pull up in a car with whatever it may be. The bank has a good faith belief that this person is the victim of either actual or attempted financial exploitation. The bank says, we're putting a pause on this. The bank has 15 days. That individual themselves might not file something. The bank can certainly contact AG or some state entity and say, we have a concern, or local police department, whatever it may be, to contact and say, we've got a concern, something might be going on here. That could lead them to go to the person's son, daughter, family member, husband, whatever it may be. That has the potential to lead to potentially a complaint for financial exploitation. And that's all I'm saying, is that could take place quicker than preliminary injunctions or something like that, because we do have that process for that type of action.
In fact, keep upon a court order directing the release of funds, because that could go through that case that you're describing.
Well, it said, the authority to delay a transaction expires at the earlier of 15 business days. And so if 15 days go by and nothing happens, it's over. If the covered entity decides, oh, we were mistaken, everything is okay, or upon a court order directing the release of the funds. My thought was, if the concern is 15 days isn't enough time for us to make the filing with the court, to extend things or to take care of things, there is a process in place that does address financial exploitation that theoretically could come into play. The covered entity may not have any knowledge, and anything they do might not bring it into play, but there is that potential.
One related question is that if we didn't have the upon a court order directing the release of funds, that doesn't mean that wouldn't be an available remedy. I mean, that person could go and seek. It's just unlikely. The whole thing just seems unlikely. But I don't need that language of that upon a court order, because if the court comes in and orders that the funds should be released, the funds have to be released. You don't have to put it in statute.
You don't. The only reason you might want to put it in there is because there's three things that happen. Either there's this pause, there is satisfaction that everything's okay, or the court says release it. But you are correct. If a court orders it released, you don't need a statute to say the court can order that.
I just think that this concept was oversold at the caucus when they were talking about, no, they could just go get a court order to have it released.
No biggie.
Thank you, Judge. Anything else?
No, that's all I have, unless there's any further questions.
I appreciate it. I look forward to having you weigh in on the other bill tomorrow afternoon. Well,
Terry and I will both be, I think I'll be remote, but Terry and I will both be available. Thank you.
Thank you very much, Judge.
thank you.
Great day.
Chris,
Take care.
why don't you join us, Chris? Are we getting any closer to satisfying?
I'm sorry.
Are we getting any closer to satisfying your concerns?
Yes. For the record, Chris Delia, President, Vermont Bankers Association. So I'm just going to quickly go through the bill because as Maria and Michelle were talking about some changes, I was putting kind of check marks next to some items.
Okay.
So
We're not going through every change that doesn't have anything to do with us.
you don't want to do that right now?
Great.
Well, you do have some questions that came up that are in yellow.
Yeah, no,
Okay.
that's true.
So
Absolutely.
page 1, an official valid, I put a check mark to that. That's fine. Page 3, where you've got the conflict of interest piece, that's fine. Check. I look forward to seeing what you come up with for the abuse definition, and we'll just circle back with you when you decide what that is.
Use definition, it was suggested to have an offline discussion, and there's interested parties in here that I don't know might want to be involved in that. Just want to throw that.
Yeah, I think actually where we landed in a conversation with Judge Zone is that we're going to use the definition of abuse that's in 15 VSA 1101 and just make it clear that it doesn't have to be between family or household members.
That's what I thought too. Just in
And
case,
we'll have Chris and Weber.
just in case that conversation still happened, I just wanted.
We'll participate in any dialogue that you establish.
Appreciate that.
So then I'm going to page 15. So this morning I got an email questioning the issue of default judgment, which I shared with Representative Goodnow. And what I'm checking out, and the individual got back to us and offered 2 suggestions to modify the definition in coerced debt dealing with the judgment. We since sent the language that's on page 15, 16, and 17 to the individual for his review. And I'm waiting to hear back whether that satisfies it or whether we would still request the language that I have given you. It's not striking, it's adding in the definition piece if you want to check.
The one thing I want to just ask is, when you send this language, or maybe you can supplement when you send what you've already sent this language to that individual, the jurisdictional question. So his initial language was a lot broader, like any default judgment, not specifically tied to a Vermont court. And I don't know how that would work with a ruling on a course debt in a Vermont court for default judgment outside of Vermont.
Okay,
So I would just,
I
if we
will-
can just flag that for him
Sure.
when he's looking at it, just so they understand that that's part of why we narrowed it
Yeah.
with this sort of filler language.
so because this is outside of my
Yeah,
area, can you just help me to understand that if we have a customer who resides in Florida, for example, and the customer were raising an issue of course debt, is a Vermont court going to deal with that, or is a Florida court going to deal with that? I just don't know.
and the banks in Vermont,
And the banks in Vermont.
they can bring it in Vermont. You'd have,
Okay,
right? I mean, like, I think that's how it would work. We can get a smarter person to talk about it than me.
only because we obviously have banks in Vermont, but we have customers all.
Yeah, I think if the default judgment was brought in Vermont, which would make sense if, that's where they are and they probably
Yeah.
would bring it here, then this would satisfy it. I guess I would just, that was just, I don't have
Yeah,
the answer
just-
for you, but just that's kind of the
Clarifying that
clarifying
it would
question.
be in the Vermont jurisdiction,
Yeah.
not a broader jurisdiction.
Yeah, and like how, yeah.
Okay. On page 15 on line 18, the creditor shall have a cause of action against the perpetrator. This was a question, Representative, that you had asked me the other day. What do other states do in this area? And I provided to Representative Goodnow a sampling of what the other states have done. What I'm trying to decipher is whether this one sentence is sufficient compared to a paragraph that is representative in those other bills. And again, I shared that with you, and the more clarity we have, the better. I'll just give you an example of one paragraph. And in this paragraph, the claimant is the creditor. A person shall not cause another person to incur a course debt. A person who causes another person to incur a course debt in violation of a subdivision shall be civilly liable to the claimant, that's us, in that bill, for the amount of the debt or a portion thereof determined by a court to be coerced debt, plus the claimant's attorney's fees and costs. That's obviously much longer than this sentence that you have here. So we would just want to seek as much clarity as possible, because that's the only person, if they are known, that we can go after. And then I jump to page 15 and looking at what has been established here. And if I understand this correctly, as described today, a sworn statement that's provided by the debtor expressing concern about potential abuse, future abuse, family harm, etc., and the danger that exists. If a creditor goes to court related to that question, the burden of proof is on the debtor by a preponderance of the evidence in the way the judge had reworded that. I don't see any difficulties with that from our perspective. So
Is that getting a check?
can I just see the judge's rewritten language for us?
I'm just eager.
You know, words matter, right?
Yeah.
So I gotta see it first. And on page 17, the issue of sealing the court records in order to protect the individual family is completely understandable and outside of any requests or comments that would be appropriate for us to offer, I think. And I didn't see any issue on page 18 with the language that's in blue regarding the timeframes that you all have established in, or trying to tie it to a timeframe, if you will. And then just go to, since you've had the conversation about it, as Maria adequately described to you, the concept about the transaction hold is one that we've seen adopted in other states, and it's all about fraud. And the notion is that my mother walks in, she is exhibiting unusual behavior because maybe somebody's on a phone in her pocket or pocketbook, and she wants to take out $10,000 and she never does that. The notion behind the hold is to provide a time for one, a cooling off, if you will, and a reflection on perhaps her part, but more importantly, an opportunity for the financial institutions to have a conversation with her, and if need be, communicate with, as we do, local law enforcement, Secret Service, FBI, whoever, to try and bring them to the table to say, hey, mom, this is not a good thing. But part of that is also we often engage with adult protective services. And the notion there is if they want to step in, our thought here was not from the perspective of the customer immediately going to court and trying to get some relief, was in the event, if there was a court order, we would have to respond to that court order.
Right.
With APS or whoever. So,
and I'm fine with it. It's just that this was wildly oversold.
Got it.
In our public caucus that, well, you can just go to court and get a, and get the court order to do this. And that was where I understand where you come from. And I think this is great. This is a great part of this bill. But just wanted to camp down some expectations of really what that meant. So, but it sounds like we should keep it there and perhaps just when it's presented, I'll make sure that whoever's presenting this component part.
Right. I think it's one of those things where a place card holder, in the event that there was an order,
in the unlikely event.
Yeah, right. But that's the notion behind it.
Yeah, no, I understand. Makes sense.
So again, I'm just checking up on that definitional piece. We'll wait to see what you come up with for abuse language and how that section is rewritten with the judge's comments.
Excellent.
Right, so there's those three items.
Yeah, and I've got them noted down too.
Great. Thank you. Any other questions for Chris? All right, we'll hear from Charlie and then I guess we'll have to go to the floor. I was hoping that would expand. No, I'm just kidding. I'm excited to go to the floor.
Fingers.
Oh, that's right. We do have to get out there in time.
Oh, in that case, Charlie, hustle.
I'm always hustling.
I'm just joking.
Oh.
We're very excited for your testimony.
I have nothing to say.
Woe is me.
Good afternoon.
Good afternoon.
I'm Charlie Glisserman. I'm the policy director at the Vermont Network Against Domestic and Sexual Violence. I will be brief. Overall, we feel comfortable with the revisions in green. I would like to speak to two questions that were up for discussion in the committee today. First, on the language that Chris referenced around a creditor's rights and right of action. We don't have a strong preference between the language that is in this draft right now and other states' language on creditors' rights. I would defer to the committee and to legislative council about whether further clarification on that language is needed. On the question of the definition of abuse in future abuse, I really appreciate the discussion, and I agree that it would be problematic to confine that future abuse to interactions between family or household members or current or former dating partners, because this bill can be protective of a vulnerable older adult who is facing exploitation from a caregiver that doesn't live with them and has never had a romantic or sexual relationship with them. So I
am also thinking on the fly, but I believe that Judge Zoney's suggestion would provide the coverage needed for all of the populations that are served by this bill. I think that this provision is very important, and there are some insights from other states that I just wanted to share briefly with you about why. What I hear from advocates in other states about the survivors that are using methods of relief like this, it's roughly two groups of survivors. It's survivors who are at a point where they have sought safety, and they feel comfortable taking a step like this. And those are the survivors who might be less likely to need safeguards within the process, or maybe more comfortable disclosing the name of a perpetrator. There's also a second group of survivors who apply for coerced debt relief because they truly have no other options. They are in a domestic violence shelter and they can't find permanent housing because their credit score is so damaged. And this is the only way that they can get out of an emergency situation. And so I think for those survivors, this kind of language that covers all the population served in this bill is very important. And I appreciate the committee's consideration. I do not have any other comments for you all, but I would be happy to answer any questions or speak to the issues that are coming up for you.
Questions?
Appreciate the collaborations, everybody.
Thank you very much.
Thank you so much. So just in the last few minutes I have, just to touch base about a couple things. So tomorrow, I do have some potential votes scheduled, 4:10, 7:44, 8:49. Those should be on the latest agenda as well. And then we'll start in on a drive-by that we have to do, and I apologize for the timing on this, on the landlord tenant bill. That's H732. If anybody wants to look at that, most of that 33 pages does not have to do with us. If anybody wants to look in advance, let me know and I'll tell you what we're going to be looking at. And we have Ashley Bartley, Representative Bartley, coming in to give us an introduction to that at 11:30. And then in the afternoon, we have 4 witnesses, Judge Zoney. Well, we have a walkthrough by Cameron Wood, Judge Zoney, and a person from the landlord tenant side of the equation, and then from the landlord and then from the tenant side as well. So next, in case I don't have time, I guess we can talk a little bit about this tomorrow since we only have 5 minutes. But I want to talk about the week that we're going to be when we get back, the week before crossover, but we can talk about that.
What were the 3 bills again?
It's 744, that's the rule, 410, we're gonna have language.
Yeah.
And 849. So we will adjourn until tomorrow. Okay, we're not.